Hello, everyone. My name is Antonino Salmeri, and today I'm going to guide you through the legal aspects of space resources activities. First of all, a little bit about my academic background. I have a master's degree in law that I got at the University of Catania in Italy. I also hold an LLM in European law and government that I got at Luis University of Rome. And then I started my space studies at the University of Leiden, where I got an advanced LLM in air and space law. And finally, my last academic effort was participating in the space studies program organized in 2019 by the International Space University. Based on my studies, my current profile is that I am a doctoral researcher in space law at the University of Luxembourg, where I'm pursuing a PhD on space resources activities and especially enforcement challenges of space resources activities. And I'm also a co-lead of the Space Exploration Project Group within the Space Generation Advisory Council, which I invite you to join if you are under 35 and you want to participate in space activities, bringing the perspective of the young generations, which is what SJC does. I'm also an individual governing member of the International Space University, which is also another entity that I advise you to join in the sense that you should, if you have the time and if you have the willingness of being an active member of the space community, you should consider joining one of the programs of the International Space University. And even with the COVID, you will have this possibility for this summer to join a new program called the Interactive Space Program. And if you want to know more about it, please feel free to email me. Lastly, last but not least, I'm also an attorney at law. I'm registered at the Italian Bar Association, although I don't practice law every day since I'm working as a researcher as to now. So enough for my background. That was just to give you an idea of why I'm giving you this lecture, because that's my area of specialization. And I also want to underline that this lecture will be based not only on theoretical analysis of space law, but also on a practical perspective. So I don't just want to talk about what is what are the main legal aspects in theory, but also how do we practically implement these aspects in the everyday practice. Now, we're going to talk about two main questions. First, we're going to address if the use of space resources is actually permitted under international space law, and assuming that it is permitted, that's a little spoiler, how should such use be governed? And that's actually the most interesting question these days. I will also talk about some recent developments, and then we will conclude our lecture, hopefully in 1 hour. Before that, it is worth doing a very brief space law recap. As you know, space law is a domain of public international law, but it is recently expanding also within the areas of administrative and private law. This is because of the so-called new space phenomenon that is bringing space law further the traditional, let's say, activities of states to a more commercial and dynamic market, as it is now with new companies like SpaceX, for instance, but also iSpace, and so on and so forth. The current system of international space law is based on the so-called Corpus Juris Spatialis, which is a corpus of 5 international treaties which have been concluded between the 60s and the 70s. Now, these 5 international treaties govern the main aspects of space in general, space activities. The most important one, the one that everyone is following these days, and the one that you definitely have to know, is the Outer Space Treaty, which so far has 109 parties, is the most ratified space treaty, and it is considered to be the Magna Carta of space. It is a treaty that provides you with the main rules of space activities, and it is a treaty that has managed to remain very much relevant even after 50 years of its anniversary. The Outer Space Treaty gives the main rules, and then some of them have been specified in further treaties, like the Rescue and Return Agreement, which deals with humanitarian aspects and return of space objects, the Liability Convention, which lays down, as the name says, the liability rules for space. And as you can see, those two treaties are as much as ratified as the Outer Space Treaty. And then you have the Registration Convention, which provides the rules for the registration of space objects. and makes this as an actual obligation under international law. And then you have the Moon Agreement, which is the least ratified treaty. Some states do not even consider it as part of international space law, namely the United States. And it has been drafted for regulating the use of space resources. So today we're going to talk about the Outer Space Treaty and a bit about the Moon Agreement as well. Now, first of all, our question is whether or not the use of space resources is permitted under international law. And it is fascinating that if you would have asked this question 10 years ago, you would have got a very controversial answer. But in the last 10 years, there has been some developments and evolution in the debate, which will bring us to conclude that, in fact, the use of space resources is permitted. But let's go step by step. First of all, we're going to consider, as I mentioned, the Outer Space Treaty. Now, the Outer Space Treaty articles that will be relevant for this lecture are Article 1 of the Outer Space Treaty, Article 2, Article 6, and Article 9. If you have done some space law, you already know what we'll be talking about, but very briefly, Article 1 provides the freedom to use and explore the space. Article 2 provides the non-appropriation principle. Article 6 regulates the activities of private entities in space, and Article 9 establishes the principle of non-interference and non-harmful contamination of space. Now, starting with Article 1 of the Outer Space Treaty. As I mentioned already, this article provides the freedom to explore and use outer space. Now, this is, for instance, in comparison with air law, the golden rule of space. Whereas in air law, everything is based on sovereignty and you cannot do anything unless it is explicitly permitted. In space law, it's the opposite. Freedom is the main rule. Therefore, everything that is not prohibited is permitted. Importantly, the freedom to use space is referred to states, not to private entities, but to states. Every state can do and can perform freely space activities. It doesn't need any permission from anyone to undertake any kind of space activities, including space resources activities, unless these activities are in contrast with the provisions of the Outer Space Treaty. So the general rule from the Article 1 is freedom. But already in Article 1, this freedom is limited by many other constraints. First of all, the freedom of other users, right? We used to say that my freedom ends where the freedom of others begin. And it is the same in space. You cannot do anything that will jeopardize the freedom of others to perform their own space activities. Second, Article 1 also provides for the need to ensure that space activities are beneficial for all countries, which in a way it is a kind of a controversial principle because we still don't know legally if there is an obligation to share benefits and what does it mean. But so far, this is also to provide a sort of moral and political tone to the exploration of space, which should be conducted for the benefit of all countries. And I can tell you that benefits can be shared in many ways. Just even the fact that a technology has been researched and discovered and then shared with the rest of the world, it is already a benefit. Imagine the GPS system, which is freely shared by the United States with the rest of the world. That is a way to ensure that space is beneficial for all countries. Article 1 also provides for the obligation to preserve scientific investigation, which is a very interesting principle because it also gives you the idea that space should be preserved also for science. So in performing your activities, science should be taken into account and should be preserved. Because, of course, as a species, we would like to explore and study the solar system and the universe, and this is an important endeavor protected by the law. And then there are also other rules of international law because as per Article 3 of the Outer Space Treaty, and already Article 1 kind of hints to that, general international law is applicable in space. Then we have Article 2, which provides the most important limitation in the exploration and use of outer space. Article 2 says that space and celestial bodies are not subject to the national appropriation of any country by any means. This is called the non-appropriation principle, and Tronchetti, who is an important professor of international space law, rightly said that it is a cardinal rule. If we remove the non-appropriation principle from the system of space law, the whole system would collapse. Because, of course, if you can appropriate a part of space, then it is not anymore available for the free use of others. So if you think about it, it is, of course, a very fundamental rule. And in a way, it has worked so fine, and it has never been challenged. Right now, it is even considered to be customary international law. So it is binding for everyone. So when you hear discussions about a state that would like to withdraw from the Outer Space Treaty, or that is considering whether or not joining the Outer Space Treaty because it doesn't agree with the non-appropriation principle, and to be fair, there are no such states right now, but in case you hear any discussion like that, you can reply, well, it would be absolutely irrelevant if this state is not a party to the Outer Space Treaty, because the non-appropriation principle is customary international law. It is binding for everyone, and I think no one that is interested in space activities should ever question this principle, because it is the starting point that we have to accept in order to make sure that space is available and free for everyone. Then the prohibition of appropriation has been discussed whether or not it applies to space resources, right? This was the debate that I referred before. Until 10 years ago, everyone would have said, or at least you would have had a very heated debate as to whether Article 2 includes also the prohibition to appropriate space resources. Well, these days, after some recent developments and studies, we can argue that Article 2 doesn't apply to resources. And this is because of many reasons, but the most important, you can find them in this slide. First of all, Article 2 only mentions celestial bodies, not resources. It means that you cannot appropriate the whole body, but you can extract a part of it and then appropriate what has been separated. And indeed, this makes sense because the use of space resources directly comes from Article 1 of the Outer Space Treaty. If I am free to use outer space, of course I can also use space resources. Otherwise, if we would have a prohibition to use resources, we would never be able to have sustainable, long-term, and permanent human exploration of the solar system, simply because it would be too expensive and it would be unreasonable to expect that whatever you need in space, you would have to bring it with you from Earth. Imagine if you have to build a station on the moon, does it make sense to bring every material from Earth, or would it make much more sense to use the regolith already available on the moon? And by the way, an ESA studies recently showed that the use of human urine can be assembled with regolith to establish concrete and therefore build a lunar base. What of the two options that makes more sense to you? Of course, the one that includes the use of space resources. And since the law, it is made also to regulate human activities in a reasonable way, the interpretation of treaties can never conduct to unreasonable results. So we can conclude that the prohibition of appropriation does not apply to space resources. And then we move to Article 6. Why I included Article 6? Because, of course, you hear these days that the most, let's say, recent and concrete plan to actually use space resources are done by private entities, not by governments. And therefore, we need to answer the question as to how private entities can perform space resources activities and if they can do that. Now, Article 6 says that private entities can, in fact, engage in space resources activities as much as in every space activities, but only under the previous authorization and continuing supervision of a state. This means that you cannot start space resource activities without a state that will give you authorization and will continuously supervise you, a state that is party to the Outer Space Treaty. In this case, it is very important. Such state is obliged to ensure that these activities comply with the rules of the Outer Space Treaty, and it's internationally responsible for violations, meaning that if a company makes a damage, if a company screws it up, let's say in a more slang language, the state that authorized and was supposed to supervise that activity will be internationally responsible, which can lead to a lot of consequences in international law. So this is also a way to connect private entities and public entities in the performance of space activities. Therefore, planning of space resources activities is allowed for private entities. But there is one last article we should mention before we conclude our analysis of the Outer Space Treaty. Very brief analysis, of course, but it gives you the main things that you need to know to get an idea of how the debate evolved. The planning of space resources activities should account for the corresponding interests of other states parties to the Outer Space Treaty. This is because Article 9 provides that companies and states, actually, to be precise, should pay due regard in performing their own activities to the corresponding interests of other states. Therefore, when you are conducting an activity, you need to make sure that whatever you're doing does not interfere with whatever is already ongoing in space. Therefore, outer space resources activities cannot interfere with ongoing existing activities, but according to Article 9, once they start, they will also be protected against harmful interference from newcomers. This is the famous so-called first come, first serve principle, meaning that whoever started is protected, but then, of course, the newcomers will have to respect the interest of the activities already started and will be protected by other newcomers. This is a simple tool for coordination, but it ensures that whoever is coming second will be considerate of whatever is already going on, because this person itself will like to be protected by the third and fourth comer and so on. And it is also a rule that makes sense in space. I understand that some of you may have concerns with that, but space is a very hazardous and difficult activity. It makes sense that the first that started the endeavor, that put the resources, that invested the money, that invested the time and the research, that took the risk, that showed the way, are also protected more than those who comes after. It makes sense if you think about it. Again, it is a reasonable result, and that's what the law should achieve. Now, Article 9 also provides another principle, which is the principle of non-halfling contamination. The non-halfling contamination principle says that it is prohibited to harmfully contaminate Earth with foreign materials from other celestial bodies and outer space. And likewise, it is prohibited to contaminate another celestial body with materials from Earth. This is a provision meant to ensure that the search for life conducted by astrobiology will continue to be preserved despite space activities. Now, it is unsure how this applies to space mining, right? To what extent you can mine a celestial body before someone is saying that you are contaminating it? What does it actually mean, harmfully contaminating? We don't have consensus on that, but what we are trying to achieve consensus on is the duty to clean up, which is also related to the sustainability of space activities, which is now a very important topic and subject that everyone is paying attention to. Even if you look at the US plans for space resources and lunar activities, you always hear about sustainable lunar activities. And a duty to clean up is part of a sustainable plan to ensure that whatever you did on the moon or on another celestial body, for what it's worth, will be finalized once you leave, in a way that, of course, you ensure that others can come. Again, we come back to the fact that you have to respect the freedom of others. So to conclude, and I already anticipated you the answer to this question, is the use of space resources permitted? Well, the position that we now have has been summarized by the International Institute of Space Law in 2015, which says that in the view of the absence of a clear prohibition, one can conclude that the use of space resources is permitted. This position has been officially declared by the United States, the Grand Duchy of Luxembourg, and more recently also the United Arab Emirates by the enactment of national law, which means that you have some states that took an official position in legislation saying, yes, you can perform space resources activities. This is why we are talking about also private companies, because this legislation allows private entities to do space resources activities. In 2016, the United Nations Committee on the Peaceful Uses of Space, which has been the main body producing international space law for over 50 years, although in the last recent year it didn't produce anything binding, adopted a new agenda item on space resources. Why then I say that the debate on the use of space resources, at least the permission in international law, is now clear? Because in 2019, during the opening statements and the working of this new agenda item on space resources, no state has opposed the use of space resources anymore. So before, you would have heard states taking the floor and saying this is illegal in international law. Now you don't hear that anymore. What you hear instead is we should discuss whether this has to be done with or without a prior international legal framework. Right, this is what we need to discuss now. And that's why our second question is, how should space resources activities be governed? Assuming that they are a legal and lawful activity under international law, that you can appropriate space resources, the question, the real point that we need to solve these days before we start space activities, space resources activities, is how? How do we make sure that this is done in a way that is compliant? with the Outer Space Treaty, that doesn't create conflicts in space, that avoids interference, and so on and so forth. Of course, we will not solve this question today, but I will give you what is the state of the debate in international law and what are my current views on this issue. Now, the first option that you hear about how to regulate space resources is international governance. Now, international governance is laid down in Article 11 of the Moon Agreement. We already mentioned that the Moon Agreement is, unfortunately, or fortunately, depending on your views, a very, not very popular treaty. It only has a bunch of ratifications, only 18 states, and none of them is a major space-spending country, meaning that basically the countries that will do space resources activities are not bound, but what are we going to talk about? Still, the common heritage of mankind is worth to be understood in order to see why everyone has been so critical about it and whether or not this criticism is justified and what can we do to move forward. Now, first of all, we need to precise that the common heritage of mankind is different than the province of all mankind expression that you can find in Article 1 of the Airspace Treaty. Second, we will discuss what is the origin of this legal principle and what does it actually entail for space resources. Now, first, what is the difference between common heritage of mankind and province of all mankind? Well, if you are a lawyer, you will understand already that from the language, there is a difference. The province of all mankind is a political principle, which is meant to declare space as a peaceful and shared domain for all countries. Some international lawyers see the province of all mankind principle as the legal basis for considering space as a global common. You may have heard about this debate recently, whether or not space is a global common. Some lawyers say, and I'm one of them, to be honest with you, that yes, space is a global common. But this only means that it is a space, sorry for the word joke, it is a space for everyone. It is peacefully shared by all countries. This is what global commons mean in legal terms. It only means that everyone can go and make use of that space. That's it. And this is why Article 1 says that the exploration and use of outer space shall be the province of mankind, meaning that we want to preserve space as an area where everyone can go beyond national jurisdiction. This is what the province of all mankind means. And it is, in fact, a more political than legal principle besides the implication for global commons, which, by the way, are not settled in international law. This is still sort of debate, although everyone operates under the assumption that space is, in fact, a global common. Now, the common heritage of mankind is a different principle. It goes to another level, and it establishes a special legal status for space resources. So it goes further and says that a certain resource is the common heritage of mankind, which legally means that it belongs to everyone. The province of mankind does not establish any kind of property or relationship with the status of space. It just says that it's open. Common heritage means that it legally belongs to all of us, and therefore its use has to be legally regulated by all of us, or at least internationally. You see the difference. Now, the first common heritage of mankind regime has been established by the United Nations Convention on the Law of the Sea. It was proposed by the Maltese ambassador Pardo in a very famous speech at the UN. And it has been created to govern the exploitation of the mineral resources contained in the deep seabed. And it is very complicated as a system. Some likes it, some don't. It is not the place to discuss about this now. But what can I tell you about it? It is a very detailed system. There is an international authority. There is an obligation to share monetary benefits. There is a lot of administrative procedure to go through the application system. It is very cumbersome in a way. And that's why, guess how many companies or countries have actually exploited the mineral resources contained in deep seabed? Zero. No one. Some say it's because of technology. That's right. Some others add that it is also because of this system. So it is a system to look on as the common heritage of mankind, but the common heritage of mankind principle designed in the deep seabed, for the deep seabed, in the United Nations Convention on the Law of the Sea, it's not the one proposed in Article 11. In fact, the common heritage of mankind regime in Article 11 belongs to the same genus, meaning that it is part of the same type of reasoning about what is the legal status of a resource, but it is regulated and works in a very different way easier, more practical and flexible. Now, the common heritage of mankind regime in Article 11 allows for the use of lunar resources under an international regime aimed at ensuring the sustainable exploitation of those resources. Again, the word sustainability comes back into mind. Now, the first three principles mentioned in Article 11, which you can read, I didn't put the text here because of limited time that we have, but it basically talks about the orderly and safe development of the resources of the moon, the rational management of those resources, the expansion of opportunities in the use of those resources. Now, if you ask me, I don't see anything new in these three principles, right? They basically restate rules that are already in the Aerospace Treaty. Of course, we should aim for an orderly and safe development of resources on the moon. Who would go for an unordered development or for an unsafe use of them? Of course, we should ensure the rational management of those resources. Why? Because they are not renewable. What is on the moon, it's everything we will find ever on the moon. If we start mining everything in 10 years, there's going to be nothing for the future generations. Again, sustainability, which is not a concept that was born with the Moon Agreement. It was already in the Aerospace Treaty. It is very important these days in space, and it is in every plan that you see for space resources activities. And third, the expansion of opportunities in the use of those resources. Again, connected to the fact that space is the exploration and use of outer space is the province of all mankind, and the fact that it has to be beneficial for all countries, meaning that if you find out a technology that is perfect to mine the moon, you shouldn't keep it for yourself. You should ask a price for it, but you shouldn't keep it secret. You should share it with the rest of the world to expand opportunities in the use of the resources. Those are very basic principles that everyone can agree upon. What is the real apple of discord is the fourth principle of Article 11, because it demands for an equitable sharing by all parties to the treaty in the benefits derived from those resources, in a way to balance the interests and needs of developing countries and the efforts of the pioneering ones. This has been the real element of criticism that everyone has for the Moon Agreement. And as every element of criticism, you have different perspectives and polarized opinion. The industry believes that this principle is too demanding, right? And in a way, they're right. We don't even know if this will be profitable in 10, 20 years. Do you really need to ask for sharing any benefit now that we didn't even start and that we will not make any profit out of it? So why should we share benefits if this is already a sort of very difficult and high-level investment? Which makes sense. On the other hand, developing countries says this is insufficient because benefits can be anything, as we already discussed. We want some more assurances that you're not gonna exploit the moon just for yourself, or the moon or any other celestial body. The truth is that letter D of Article 11 has been left vague on purpose. Guess what? If it can raise to such polarized criticism, it's because no one really knows how to implement it. And then we come again to the question that we're trying to solve here. What actually do we have to do to ensure this balance between pioneering countries and developing countries? Now, the Common Heritage of Mankind regime, which says that an international framework should be established as soon as the exploitation of space resources becomes feasible, is only binding for those parties. It has 17, 18 parties. None of them is a major space nation, as we said. But in a way, and this is the message I would like to say to you, I'm not saying that we should revive the Moon Agreement or we should use Article 11. I'm saying that this is based on common sense. And any type of regulation, any type of approach we will see for space resources will not be so different than at least the first three principles of Article 11. So its content should not be forgotten in future regulation because it aims at the sustainable, rational, and ordered use of space resources, which is everything that we need to keep in mind to do this in the right way. Then we have another regime, which I wanted to briefly talk to you about, which is the allocation of geostationary orbits and slots under the International Telecommunication Union. Now, this is looked as a more suitable model compared, for instance, to the deep seabed mining or Article 11 of the Moon Agreement. And it is a system that has worked so far for managing a scarce resource, which is the orbital slot in the geostationary part of the Earth orbit. This management of scarce resource is done by the ITU at the international level, and it is based on 3 pillars. The first pillar is that this is regulated internationally. The second pillar is that every allocation has limited duration in time. And the third pillar is a reserved slot system for developing countries. Now, very briefly, this management is done by the ATU. Every state has a certain slot and can use these slots for a certain amount of time. Then the allocation expires and you have to apply again. And some slots have been reserved for developing countries, meaning that they will not be allocated until that country will be able to use it for its own companies or its own plans and activities. Now, between the Moon Agreement and the ITU, I think there are all the premises to build an international good system for the benefit of humankind. What is the problem? And you already guessed that. It is that international regulation is difficult, it's costly, and it's very slow. It may take decades before we develop a full international system. It takes a lot of time to negotiate a treaty. You have to balance a lot of perspectives. And in the meantime, what do? The possibility is that we will never agree because you see there are very polarized opinions. What do we do in the meantime? Are we going to let all these resources sit down on the moon and in asteroids and on Mars and never use them? Do we really want to prefer nothing to the possibility of progress? This is the question that brings us to national governance, which should not be considered as an alternative to international governance. It should be considered as a first step towards the adoption of future international regulation based on the principle of adaptive governance, which means that we should regulate what we are able to do now, and what we need to regulate now, and then the rest will come in the future, which does not mean that we shouldn't be proactive. It means that we should be reasonably proactive, which is, again, different. Now, the first example of national regulation of space resources activities is the United States Space Act of 2015. You probably already know about this. It generally authorized space resources activities. It explicitly mentions compliance with international law and does not provide any further details. Basically, in 2015, the United States said, we want to express our opinion that space resources activities are legal under international law. This is what we're going to do. We're going to have a law saying that US citizens and companies can do this. That's it, though. There is no more. And if you read the law says this is possible, provided that it is compliant with the international obligations of the United States. So this is not to be intended as a sort of challenge to international law. It is not to be intended as a unilateral approach. It is a stance. It is an interpretation. It is what the United States thinks of the regulation of space resources activities. It is not binding for other states. It is not actually, so far, it doesn't imply anything further than that. It is a statement that starts a discussion. And we have to be honest, if it wasn't for this act, we would never have a debate these days on space resources. So the purpose was achieved. The purpose was, let's have a concrete discussion on this. And this is what we think. And then here is what you think. And right now we know that they were right. In a way, everyone in the end agreed that we need space resources for space exploration, and we need to consider them legal. We want to consider them legal because it would be unreasonable not to do so. What we have to debate is how to regulate them, which is a topic that we are debating these days. Now, the US position has been followed by Luxembourg in 2017. It adopted a law saying the same: space resources are capable of being appropriated. And more than the United States, it provided a procedure for obtaining authorization to such end. This is important because still to this day, 2020, today is 12 May of 2020, the United States did not provide any authorization regime, never said how a license for space resources activities will look like. There is nothing. Luxembourg instead said, yes, we think you can appropriate space resources, and this is how you're going to do it. At least, how do you going to obtain authorization to such end? On top of that, the procedure laid down in the Luxembourgish law is open to all entities based in Luxembourg. So while the United States law is only for US citizens and companies, the Luxembourgish law is to all entities based in Luxembourg. You can be Japanese or fully German or fully American or any country you may have in mind. The important thing is you have to be based in Luxembourg. But apart from that, there is no national requirement, which is even more, let's say, industry friendly in a way. The United Arab Emirates has recently become the third state enacting national legislation in favor of space research activities. You can find it in the US space law, UAE space law that has been approved in the last month. An English translation has been recently made available to some commentators, including myself, and it will be generally spread soon. The UK and Japan may be the next states adopting such a legislation. Of course, because of the COVID and because of Brexit, UK has been some troubles in proceeding that discussion. Japan is seriously considering this option and may actually follow up with a legislation soon. Then there are, of course, the Moon Agreement states and Russia, which say that it is best to have international governance. Russia says that it is mandatory to have an international governance. So Russia says, yes, you can use space resources, but for this to be legal, it has to be regulated at the international level. This is the position of Russia, which is a position that they take on their own. They're not party to the Moon Agreement. They don't consider that regime to be the best, but they say there has to be something internationally. And then you have the Moon Agreement countries, which says, well, yes, of course, we need an international regime because they are bound by a treaty which provides this international regime, or at least which provides for the obligation to have an international regime. And then you have the case of China, which is very interesting because China started with a position similar to Russia, saying that there has to be international regulation. And then it kind of, I think, understood that this regulation is not happening soon. China has a lot of interest in doing activities on the moon, including space resources activities, and therefore is switching to national regulation. It didn't adopt, as we know, any national act on that, but it is moving, let's say, it is considering this idea. And this will be interesting also at the end of this lecture when we will talk about the recent developments. Now, one can see that the benefit in having national regulation. You can already hint some of them. First of all, you have support for technological development. You have legal certainty for the industry and protection for the public. Some law is better than no law, and some action is better than no action. So if you have a national law saying that you can do space resources and you have to comply with these rules and you're going to be supervised and you're going to be authorized, this is positive. It is good. It means that we know how this is going to work. It ensures transparency. It ensures funds and financial support for the industry. It ensures that we will keep technological development going. We will support this. And it will also protect the general public, because in the law, we can also put some provision saying you need to consider the environment of the moon. You need to consider the Apollo 11 footsteps. You need to consider this and that. If you don't have a law, if you're waiting for some international regulation to happen, all of this will be lost. But to be fair, on the other hand, there are also dangers, of course, to be very open and transparent about this. First of all, the main risk is overlapping claims. Now everyone wants to go to the south pole of the moon because they consider it very interesting because of the ice and the peak of eternal lights. But the south pole of the moon is not so big. It cannot accommodate so many mining operations. It can only accommodate probably one mining operation at the time. So what do we do if China goes there first and the US comes second, or vice versa? It doesn't really matter who is first. It matters that we have two countries, two actors, two entities that want to go to the same place, and they have each in its own legal regime, legal claims, perfectly valid. How do we make sure this? You remember, you cannot interfere with the others. So in a way, who comes first is important because that first entity will be protected. But it is really fair that for such short and small place, we just have this decided by whoever comes first. Should not we think about how to manage this in a way that allows for international coordination and cooperation without the need to have a treaty? That is kind of the difficult problem that we have to solve. And this is also connected to the fact that the first states will get the best pieces of the cake. And on the moon, that is so much connected to humankind at all, as a whole, it is really fair. It is really what we want. It is probably legal, but it is the way we want to go for it, even for the state that will go there first. Does this state, let's say the United States, has anything to gain from being considered in international law as the state who exploited the moon just for itself? I don't think there is any political gain into that. There will be repercussions, and it is not the purpose of space activities. And if you look at the strategy that the US has with the Artemis plan, it is not what the US want anyway. So don't be trapped by fear of apocalyptic scenario or a greedy Wild West scenario of companies going there and mining the moon until nothing is left. I don't think this is going to happen. No one has to gain from that. Space is different, has been different for the last 50 years, and I'm sure it's going to be different in a positive way also in the future. And then, of course, there is the possibility that in national law, only certain interests will be considered more. So you have the possibility that environmental and social concerns could be ignored because there is no one advocating for them. We know that industry concerns are advocated by the companies, but who is going to speak for environmental and social concerns? Well, to be honest, we are seeing the development of new non-governmental organizations like For All Moonkind and the Moon Village Association talking about this, but it is a danger that we should at least consider and take into account. And therefore, here we come to my proposal, which is not entirely my proposal, to be honest. It is the general trending that we see these days, a mixed system. A mixed system is based on national regulation with soft elements of international coordination. And this is gaining momentum because of the pragmatic approach that everyone wants to adopt in view of starting lunar activities already in this decade. A mixed system would support technological and commercial developments, but it would also allow international regulation to evolve in parallel. Again, following the principle of adaptive governance, this will start slow with soft coordination and then go up and up and up and up until we arrive to a full, for instance, binding international treaty, which is not to be discouraged in at all, but it only has to come when it is the moment that it comes, when it is more reasonable that it comes. Now, national regulation in this mixed system will be based on priority rights and safety zones, plus non-interference and mutual recognition. Those are the pillars that I can tell you in the time that we have now. Priority rights mean that you're not going to appropriate any part of the moon. You're not going to have an exclusive right that will be yours forever. You're going to have priority rights, meaning that you get a specific time and portion of the moon. You go there, you do your activities. After its expiration, you go away, someone else comes. Priority means this is your turn, but it also means that in the future, it will be someone else's turn. Safety zones are connected with priority rights. They are not a way to ensure to actually go for appropriation of territory. It is meant to ensure safety, as the name says, and non-interference. A safety zone is a zone established in the perimeter of a space activity, space resources in this case, and it coincides, it overlaps with the area that you got priority rights. It is meant to ensure protection for your activity, but also the others. It is meant to say to other actors, this is what I'm doing in this area. When you come close to my area, please be careful. Please avoid interfering and be safe, because here I'm doing this activity that could be dangerous for you. So please stay out of this area. And if you have to get in, please let me know so we can coordinate. Again, makes a lot of sense, right? This is what we should do anyways, because it does not make sense to just say you can never get in, or yes, please feel free to come in even if it will destroy my operation and yours. We need some sort of common ground. And this is what priority rights and safety zones and non-interference says. Mutual recognition is a legal tool that will ensure that all priority rights recognized and enacted under a certain national law will be recognized by the others. It means that if iSpace gets the priority right to mine the south pole of the moon under Luxembourgish law, the other countries like China and the US will respect and recognize that claim, provided that it is not conflicting with another claim already existing. This is all based on the first come, first served principle. But again, because we're talking about pioneering technologies, it also makes a lot of sense that whoever makes the effort to go first and takes the risk, okay, will also be more protected, because the others will learn from the example of this first actor, and therefore it makes sense, it is reasonable again that they respect what this actor has already been doing. You can read more about this in a paper that I recently wrote for the 70th International Astrological Congress. It is called Houston, We Have a Law, a model for national regulation of space resources activities. There you can find a licensing system divided in articles that I drafted for a tentative proposal of this mixed system. International coordination has been already dealt in two main documents, let's say. The first one is the Hague International Space Resources Governance Working Group building blocks. The building blocks are, let's say, a starting point for the development of a flexible international legal framework. And those are a very good piece of international coordination tools. They have been the result of 4 years of discussion within a multi-stakeholder platform, which included academia, industry, governments, private entities, NGOs. Everyone that wanted to join the Hague Working Group could have joined. The debate was open and transparent. In the end, we got these 20 building blocks. You can read them online. There is also a commentary that I would encourage you to find. Again, it is available online. And they provide you a starting point. They're not mandatory, they're not final in a way, but they're a good starting point. And they're meant for the regulation, so at a higher level. At the lower level, let's say lower, we have the Moon Village principles developed by the Moon Village Association in complement with the building blocks. So they're not alternative to the building blocks, they are complementing the building blocks because they don't go to the regulation level, they go to the policy level. There are 15 principles meant to ensure coordination as to the operational conduct of new activities on the lunar surface. They're also broader in scope because the Hague building blocks concern space resources activities. The Moon Village principles concerns all lunar activities. So in a way, they're broader and less broader. They have a political and policy scope, coordination above all, but they concern with every lunar activity and they complement with the building blocks. Hopefully in the future, we will have a system that is based as to the regulation on the building blocks and as to the policy and the standards on the Moon Village principles. And you can also find them online. You can even give comments because they are still a draft. So they are an evolving document that you can also contribute. So go to the Moon Village Association website and provide your comments. You can also write them directly to me. I'm also a member of the Moon Village Association. I'm part of the group who is working on the principles. So please feel free to share any comments and suggestions you may have. And now we're going to go to some conclusions, focusing on the recent developments and what is that is going to happen in the next, let's say, couple of years, and what happened already in the last couple of years. Now, in 2018, Luxembourg, which I think has been probably the most, let's say, reasonable actor in this whole debate, and not just because I work in Luxembourg, but because of the actions that it took. Luxembourg started a so-called spaceresources.lu initiative. You can find the website online. You just Google spaceresources.lu. And it is meant to ensure international coordination. So Luxembourg has been the first state proposing this mixed approach. Luxembourg said, yes, we're going to have our own legislation, but we don't think we should do this alone. We don't want to do this alone. We don't want to do this against international law. We want to do this together with others. So Luxembourg started signing memorandum of understandings. So far, it signed them with Czech Republic, United States, Belgium, United Arab Emirates. Many more are coming. I think there is also one with Japan. The idea is, let's talk to each other, right? This is what I want to do. This is my law. This is my system. What is yours? And then we can adjust, and then we can find common grounds. Again, the idea is to have this mixed approach, starting with national regulation, but expanding it and coordinating it with what other states are doing, because we are doing this together. This is also the spirit of the United States, despite some criticism you may hear. On the 6th of April, the United States president enacted an executive order mandating the Secretary of State, if I'm not wrong, to seek for international support in favor of space resources activities. Now, the executive order has been discussed a lot because it is very critical of the Moon Agreement, but this is nothing new, because it says that space is not a global common, and that is actually something new for the United States, because the United States has always had the opinion that space is a global common, at least legally speaking. If you read the part of defense, the DoD, the Department of Defense national strategy for 2011 and 2012 and 2010, you can see that space is considered to be a global common, and this has been already consistent with previous DoD strategies and other State Department strategies, and it is very, in a way, weird that the United States took this stance. If you want my opinion, I believe this was meant to refer to the economic notion of global commons and not the legal notion. So the economic notion of global commons says that global commons should be shared by everyone, also as to the benefits that come from the use, the monetary benefits. And this is something that we do not have in space. So the legal notion of a global common, as we already discussed in this lecture, is meant to ensure openness, and it is meant to define every place that is beyond national jurisdiction. And I don't think the United States is questioning this. The United States, probably because of an economic and commercial perspective, is saying we don't think this is a global common, meaning that we don't feel we have to share monetary benefits. So probably the language could have been better, yes, but I don't think this is actually a problem. And to this end, you can see that from a new, very recent development, a couple of days ago, it has been released, the news that the US is working on a legal document called Artemis Accords. Now, we don't know about the content or the nature of this accord. We only know that it refers to safety zones. So does it ring a bell? And we know that it is meant to be shared with allies of the United States in the Artemis program. And it is meant to ensure coordination in space resources activities. Now, what exactly this will be, if it will be a gigantic memorandum of understanding, or if it will be a sort of new intergovernmental agreement on the basis of what has already been done for the ISS and on the likely basis of what will be done for the Lunar Gateway, we don't know. We can only speculate, and this is not the place to do that. But what does this tell us as a recent development? That the United States believe that this has to be done in coordination with partners, and that this coordination should be formalized in a document. They call this Artemis Accords. They could have called it anyways. It doesn't really matter the name. In a way, it doesn't matter the nature. The important thing is that there is the idea that we need to sit down and combine our approach. Again, a mixed system. This is my national regulation. This is how I will allow my companies. How about you? Can we find some common ground and avoid conflicts and avoid overlaps? So in conclusion, space resources activities are permitted under the outer space treaties and therefore under international law. I think this can be safely established these days. There is no one seriously questioning this premise, but it is still debated whether or not national or international governance is better, and whether or not, legally speaking, it is mandatory to have international regulation, or whether we can go with the national regulation already. A mixed system, as every time in life, is gaining momentum as a compromise, as a common ground, combining national regulation as the main source and international coordination to avoid conflicts, to ensure peaceful uses and sustainability of space resources activities and lunar activities in general. And you can see the paper that I wrote, but also other comments and articles you can find from colleagues online. And you can read the Hague building blocks and the Moon Village principles to find out about possible international tools for coordination and possible policy shared ground for lunar activities. Recent developments in policy and in international arena see the Space Resources.lu initiative gaining a lot of support internationally, and now this very late and new development of the Artemis Accords, which we still don't know what's going to look like, but it's probably going to be a sort of shared document between all the partners of the United States in the Artemis Accords. And who knows, it could be even open for new countries that would like to join. I think if it's based on the ISS model, this will probably foresee a sort of integrated infrastructure on the moon to make sure that we share cost and that we avoid interference. So again, a lot of reasonable results. And with that, I would like to conclude my lecture. I hope you found it interesting, and I hope you will be interested in space resources activities. If you have any questions or comments, you can find me at my professional email address, which is antonino.salmeri@uni.lu. You can also find me at my SpaceGen address. So again, antonino.salmeri@spacegeneration.org. Or you can find me on Twitter or on LinkedIn. Please connect if you have questions, if you have comments. If you want to participate, if you have technical expertise and you would like to do some research on lunar activities, reach out to me. If you want to discuss legal aspects, if you have questions, I'm here to help. This is the beauty of the space community. We are all here to help together. And with that, I would like to thank you for your attention and wish you all the best for your career in space. Thank you all very much.